Appearances, counsel.
Nate Carnes on behalf of the people.
Robert Hartzell for Mr. Darnell, who joined me to my right.
We are here for a pretrial. It appears there's a resolution in this matter.
Yes, Your Honor, it's my understanding that the defendant plead guilty is charged. The people are going to recommend 90 days jail with no probation in this matter.
Close, Your Honor, if I may.
No contest, Your Honor. There's civil liability potentially because of ongoing child custody.
That is correct.
All right. Sir, have you heard what your attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, please.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. Sir, it's my understanding that you'll be pleading guilty as charged to the allegation in count number 1 of telecommunications services malicious use. That is a misdemeanor punishable by up to 6 months in jail and or a fine of $1,000. I think I said guilty. You're pleading no contest.
Yes, sir.
Is that your understanding of the plea agreement?
Yes, sir.
Also, there's a recommendation from the prosecutor for a sentence of 90 days in jail with no probation. Now, do you understand that that's their recommendation and I don't have to follow that recommendation?
Yes, sir.
If I don't follow that recommendation, you're not able to back out your plea. Do you understand that?
Yes, sir.
Additionally, this is, as I said, a no contest plea, which means that the court is going to be able to review a document. It looks like it's going to be a police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that?
Yes, sir.
There's certain reasons that a no contest plea can be entered, and one of those is potential civil liability. And it's my understanding there's maybe some child custody issues going on. Is that accurate?
Yes, sir.
All right. Between the dates of October 31st of 23 and November 28th of 23, were you on probation or parole?
Yes, sir.
Has this, are you still on probation or
No,
parole?
sir.
All right. Were you on bond at the time?
Was I on bond?
Yes.
Not that I know of.
All right. Do you remember reading and signing this advice of rights form? It talked about your rights to an attorney and your rights to a trial.
Yes, sir.
Did you understand those rights? Most importantly, do you understand that you have a right to a jury trial and that by entering a no contest plea, you'll be giving up that right. You won't have a trial of any kind. Do you understand that?
Yes, sir.
Other than the agreement, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
Then, sir, it's the allegation that on or about October 31st of 2023 through November 28th, 2023 in Herring Township, Wexford County, how do you plead to telecommunication services malicious use?
No contest.
Counsel, I've been provided what's marked as People's Exhibit number 1. It is a Office of the Sheriff, Wexford County incident report, case number 83230235. Do the people move for its admission?
Yes, sir.
Mr. Hartel, any objection?
None, Your Honor.
All right, give me, People's 1 is received. Give me a moment while I review that. Counsel believes exhibit number 1 provides a factual basis in which to accept the plea and the court rule has been complied with.
Yes.
As does the court. I find the plea is no involuntary and accurate. I further find that the interests of justice are well served in allowing the defendant to enter a no contest plea. In this case, given that the plea of guilty could be used against him in any type of child custody matter. I'll also state for the record that I had been conflicted out of this case because I had been the elected prosecutor at the time that the charges arose and were issued. However, the parties that have signed a waiver of disqualification. Mr. Darnell, I find you guilty of malicious use of a telecommunications device. In particular, I find that between the dates of October 31st and November 28th, the defendant was sending text messages to, I believe at that time was probably an estranged wife, maybe an ex-wife. During that messages, he It indicated that essentially if the guy she was with was around their kids, he was going to effing slit his throat, cut his heart out, and send it to you in the mail. Also threatened to post nude photos several days. Threatened to burn, I believe it's a car, but it could be a house and a car. So I do find that the allegations are made out. And Mr. Darnell, I do find you guilty of, as I said, the malicious use of telecommunications device. Mr. Carnes, are we able to sentence today?
We are.
Mr. Hartel?
Yes, thank you, Your Honor. I would ask the court to adopt the recommendation that was presented to the court for the 90 days without probation. We do realize it's not a killer brew. I would ask the court still to adopt that. Just for some additional context, my client has another case. I'm not his attorney on that. I believe Mr. Champion is in Misaki, child support related. He expects his out date to be about the time that the 90 days would give him with credit for the amount of time served that he has. Rough estimations, it might not be 100% spot on one for one. But just so the court is aware, even if you were to sentence him to less than 90 days, he wouldn't be immediately released. I believe he would then just be transported to Misaki to continue on that case, and we don't know exactly how that's going to resolve. So there is some guesstimation between my client and myself about how he expects that to resolve. I expect him to know that case better than I do. Being a no contest, I won't overly allocute for perhaps obvious reasons, but I would ask the court to adopt the recommendation.
Thank you, Mr. Carnes.
Thank you, Your Honor. I am disturbed by these messages, particularly the ones involving burning the house down and burning her friend's car, knowing that the victim had just, along with the defendant, had just had a house burned down. I think this is psychological torture, essentially. I think 90 days is a sufficient sanction. I ask the court to sentence to that. Thank you.
So you have the right to address the court prior to sentencing. Is there anything you'd like me to know? Where do things stand with your case in Misaki County?
It's in front of the court over there. It's rearages that I owe from, I broke my neck and I have metal rods, steel cage, that stuff. And that's just what it's from.
Okay. I think how I want to ask this. How early in the breakup process was it that these messages were sent?
Right away. I mean, our divorce was not even finalized.
How long have you been separated?
Not very long, couple months, maybe tops, if that.
One of the things that concerns the court is you said in those messages that you have no problem sitting in jail. That's very concerning because that behavior tells me that no matter what I do, I'm going to continue doing what you're doing because that's what you do. You can't control yourself. I see you've got a personal protection order out against you, or at least did. I'm not sure if it's still active. 21, you had a conviction for, among other things, carrying a concealed weapon. then you got a conviction for possession after this arose. Actually, about the time it arose is when the case was brought up, but for whatever reason, you weren't convicted, so I'm assuming you disappeared on that case as well?
No, that's settled, taken care of out of Bay City. That was taken care of 100%.
Okay, but when did you get picked up on those charges?
Around July. Or like, I'm like,
Lien shows that you were convicted in November of 23, but not sentenced until February of 25. Is that not accurate?
It might be, I don't know. I definitely, in February of this year, I was in Bay City jail.
Okay.
And that's when it got taken care of.
'Cause it shows that the charge arose in July of 23. It was charged August of 23, convicted of 23, sentenced February of 25.
Yeah, they did well, because of me breaking my neck, that was where the difference was, because like I said, I have 2 metal rods, steel gauge, I gotta get everyone, I internally decapitated myself.
I'll be honest, I'm
When it comes to me and Vince Darnell and the man in the case, we have no, like, I have no hard feelings toward them at all. I think it was just at the time, because of how everything played out, like, it was so close together. I said stuff that I did not mean. And I really regret it, and I can't take it back now. It is what it is. I just want to get this settled, wasn't taken care of, and just move on with our lives.
Are you employed now anywhere?
I was up until I came to jail, and obviously I lost my job in jail. So
What did you do?
I was building brick patios and rock walls, hardscaping.
How long have you been doing that?
So I worked most of the summer. Last year I didn't work because I couldn't get clearance because of my neck. I couldn't get medically cleared, so nobody would look. But before that, the year before that, I was working for the same guy too.
Well, I'll be honest, you're lucky that that you weren't arrested at the time that this happened, because it'd be a completely different outcome for you. I would have had no problem locking you up for the full 6 months. However, almost 2 years has passed, and the only thing that is on your record after those 2 years is the conviction for the drug charge that arose in Bay City from 2 years prior. So while I believe Mr. Carnes is in his right to request the 90 days, I'm going to not order that. You have already sat 18 days on this case. So I'm going to do 18 days jail with 18 days credit. I'm also going to do a period of probation for 6 months. During that time, you're not violating the law. A report is ordered, not leave the state without the consent of your probation officer. Keep your contact and employment information current. Because this does have the domestic element to it, you are not eligible for early release. During that time, you are to attend any counseling that your probation officer determines is appropriate, including anger management. Is there a custody order in place right now with the kids?
I have them every other weekend.
Okay, but is there a custody order in place?
I guess I don't.
Have you gone, well, there must be, because you said there's a child support case pending, right? So you've been to the front of the court and?
Yes.
Okay.
Yes.
Also, you're not to be in possession of any firearm or weapon, and that you not act in threatening, intimidating, or harassing behavior. There is a $75 Crime Victims' Rights Fund fee. $50 state minimum fee, $150 fine, $150 costs, $150 attorney fee. 6 months of probation is $180. Because I have sentenced you to a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that by operation of law. Okay. When you're released from the jail today, you'll need to come over here and get signed up for probation.
I will not be released from the jail. I'll be.
Because you still have the hold.
Yeah, they'll
All right.
transfer me over to Misaki.
All right, well, when you are released, you'll need to come over here and get signed up for probation.
Okay.
Okay? Thank you. Our next call is the case of the people of the state of Michigan versus Brian Lee Kelly, case number 254265 SM. Appearances, counsel.
Hey, Terrence, on behalf of the people.
Frank Green on behalf of Brian Kelly.
We are here for a pretrial. Is there any resolution in this matter?
Yes, Your Honor, it's my understanding that the defendant will plead guilty to an added count of attempted assault and battery, and the people will dismiss the completed assault and battery.
Mr. Green? Is that accurate?
10 seconds. Yes, Your Honor, that is the agreement, sir.
Mr. Kelly, have you heard what the attorneys have said the resolution in this case is? Yes?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
So it's my understanding that you'll be pleading guilty to an attempt assault and battery, which is a misdemeanor punishable by up to 47 days in jail and or a fine of $250. In exchange for that, the people will dismiss the charged offense of assault and battery, which is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Additionally, because this happened in a place of confinement, so in the jail, you could be subject to a consecutive sentence, which means you would have to serve your other sentence first before you would start serving this one. Does that make sense?
Yes, Your Honor.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Yes?
Yes, Your Honor.
I need you to speak right up. I can't hear because of that just carries his voice to the recording equipment. It doesn't amplify it. We've got a new printer and it's kind of difficult to hear up here. So back on August 21st of this year, were you on probation or parole?
Yes, Your Honor.
Have you been violated for this behavior at all?
No, Your Honor.
All right. Have you talked to your probation officer about it?
Yes, Your Honor.
Do they plan to violate you?
No, because I was incarcerated, Your Honor.
Okay. You and I went through at your arraignment your rights in this case, your rights to a trial and your rights to an attorney. Do you remember those rights?
Yes, Your Honor.
Do you understand those rights?
Yes, Your Honor.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be waiving that right to have a trial and you won't have a trial of any kind? Do you understand that?
Yes, Your Honor.
Other than the agreement, has anybody promised you anything in order to get you to plea today?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is your own free choice to plea today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm aware of it, Your Honor.
Then Mr. Kelly, to the added allegation that on or about August 21st, 2025 in the city of Cadillac in Wexford County, how do you plead to an attempt assault and battery?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on the 21st of August?
I struck Mr. Elijah in the face with my right open hand.
And why did you strike him?
He was yelling at me to strike him.
What was going on?
I was trying to clean the shower and he was trying to take a shower and I was telling him to let me clean the shower before he took a shower because he only had cleaning supplies a certain amount of the time.
And when he told you to hit him or strike him, what describe his demeanor for me?
He was screaming at me to hit him and calling me the N-word on top of it.
And who started that altercation?
At
least the argument.
I did because he was in the shower and I walked towards the shower screaming, yelling at him. So I definitely escalated it.
Before he told you to hit him, did you have any intention on hitting him?
I mean, we've had altercations in the past, so I figured it was going to happen sooner or later.
Counsel, I can't accept the plea. It just, to me, again, sounds like mutual combat. The person asked to be struck and Mr. Kelly followed through with the request. Do the parties want some more time, or do we want to set this for a final pretrial?
I have no objection on it.
Mr. Green, I know you're up here. Do you want some time to talk with the prosecutor about the case some more? Or?
If we could, Your
Sure.
Honor, I truly think that we could resolve this morning with a brief conversation.
Yeah, we can move this one to the side and I'll give you some time.
Thank you, sir.
Court next calls the people of the state of Michigan versus Kevin Ramirez.
Just a moment, Your Honor.
Joanna Carey for the people. Thank you, Your Honor. Taylor and Anna Prevento on behalf of Ms. Hall, who joins me to my right.
This is case number 254191 SM. We're here for both a pretrial and a bond motion. Is there any resolution in this case?
We were not able to strike an agreement today, Your Honor.
All right, then Ms. Firavento, your motion.
Thank you, Your Honor. We'd like to proceed forward on arguments for bond. Ms. Hall is currently housed on an unrelated matter. She should complete her sentence on that October 27th, is my understanding. With her motion, we included a letter from Great Lakes Recovery Center indicating that she has a bed at a treatment facility, which will become available on October 28th. We respectfully request the court modify bond to allow her to be released to rehab with the other typical conditions of signing all necessary releases to community corrections to monitor that she is still there, get copies of any drug testing that may or may not be ordered as part of the bond, and also report back to jail if she was to leave early from her treatment. Or in the alternative, Your Honor, we would respectfully request just that her bond be reduced down to a PR bond or a low cash bond or low 10%, so that once she completes her current sentence, she is able to post bond. Her current bond is far beyond her financial means. Thank you.
Ms. Firavento, why the need for treatment?
It's my understanding, Your Honor, it's for issues that were present before the current matter was charged.
What issues?
I believe drugs, Your Honor.
Do you know specifically what type of drugs?
I may consult briefly with my client just to make sure she's comfortable with that disclosure. Methamphetamine, Your Honor.
When was the last time she had used?
Your Honor, she reports it was prior to her arrest on the charge she is currently serving, so it's been some time. She believes September 8th. It was just before her arrest on the current charge she is serving.
So why the need for treatment now if she's been in for over a month?
Your Honor, as this court is aware, methamphetamine is quite a difficult substance to kick. She wants to make sure she is taking the necessary steps so that if and when she is released, she has supports and she's taking those steps now, and she's not just waiting until she gets out and ending up in a situation where she doesn't have those supports, because that is a very bad situation for someone to be in and increases the likelihood of relapse. So she would like to be able to go to a rehab facility upon release.
Is she doing any programming in the jail?
She can elaborate on the program she's been doing in the jail, Your Honor, if we'll allow.
Yes, so lately I've just been seeing, the Healing Impact Ruins group. I haven't gotten started with, Cox, not as of yet, or mental health as of yet, but, just right now, I'm just doing the, Healing Impact Ruins with Adeline.
There's AA and NA classes in the jail, right?
Yes,
Have you done any of those?
I don't recall, being offered NA, but if there was, then I'd probably attend, but it's just AA that they have. And I don't attend that, but,
Why don't you attend it?
I'm a recovered alcoholic. And alcohol is not my thing anymore. I'm more on the along the line of, going to NA.
And I realize that's geared towards alcohol, but there's some, at least my understanding of the program is there's some benefits for drug addiction as well. I mean,
Yeah, it's just
the
something
tools
that-
are kind of this, the tools are kind of the same, right?
Mhm.
Anything else, Ms. Fioravento?
Thank you, Your Honor. I would just again emphasize the current charges before the court, which have not been resolved, are misdemeanor offenses. She is taking these steps as she's elaborated. She has participated in some services in the jail. She has taken the efforts to secure a bed, and we would respectfully request that she be allowed to go attend that treatment. And she is willing to make any other conditions necessary to the court, sign any necessary releases to ensure and monitor her participation in that treatment, and comply by any other orders the court would order here. We think that being in a rehab facility, being monitored and not being monitored by the court would alleviate any concerns of public safety as well.
Ms. Carey?
Thank you. The people oppose a release. She has at least 21 prior convictions. None are drug related that I see. I see 9 of those 21 prior convictions are theft related. And this current one is theft related. And sometimes I know that theft and drugs go in hand, but what we have here is someone who's stealing. The last, looks like she had 2 drunk driving, the last one in 2007, and one in 2006, and one in 2003. Nothing since, at least based on the information that I have. I don't have her record of appearance or non-appearance, but my memory is I think there was some absconding in the past, but I don't want the court to use that because I can't remember. We don't really have a lot of history regarding her substance use. We have a lot of information on that. No information really has been provided on her mental health, but I would say, as to her character and reputation for dangerousness, she poses a threat to society, given her record. She's a thief. She steals, has so many larceny convictions. That's the issue. I will admit the seriousness of this offense is not the most serious. It's not the most egregious. It's she and somebody else took scrap metal. But she's on video. The video has been, our people in our office have watched it. The co-defendant has identified her as the person with him. I think the likelihood of conviction is high. We don't really have any information on her employment history, or I understand she doesn't have the ability to post bail. But we also have no responsible members of the community to vouch for her or to make sure that she is going to do what she says. Everyone in jail wants to get out for treatment, but I don't think that this is that case where releasing her to treatment is necessary. This case should and could resolve quickly, either with a plea or a trial, And then that opportunity will still be available to her, and frankly, has been available to her. I don't know what treatment she's had in the past, but she's no stranger to our system. And this opportunity is out there, whether she's incarcerated or not. So under these circumstances, with this case and this charge, I would ask the court to deny the motion.
Mr. Vento.
And since the prosecutor addressed likelihood of conviction, may I respond on that issue?
Mhm.
Thank you, Your Honor. We do have video. It shows two individuals taking some metal and loading it into a truck. But that metal is being taken from behind a building next to several dumpster trash cans. And in consideration of that, Your Honor, we would ask the court to weigh in that fact for purposes of likelihood of conviction. And as to, again, the other arguments here, the people at the rehab, again, she is more than willing, my client is more than willing to sign any necessary releases. The people at the rehab would immediately notify the court if she was to leave against medical advice or leave early. Thank you.
Thank you. Mr. Carnes, you're on your feet.
Your Honor, if I may, I did review the video on this. The defendant and co-defendant removed metal building materials from pallets. The police report says it was nowhere near a dumpster. I think not show that according to the police report. I'll admit the only thing I remember is it was stacked neatly on pallets right behind a business, right by their rear door. I don't think it's a reasonable mistake. Scrap metal based on my review.
So reviewing the bond factors in MCR 6.106 for pretrial release, prior record, including juvenile record, is something the court is to consider. When I go through the defendant's prior record, I show there are 5 low felony convictions, 21 misdemeanors, actually a total of 29 misdemeanors, 8 of which are non-scorable. That history is made up of, in 99, a retail fraud third, 03, a domestic violence, 03, an attempted receiving concealing less than 200, 03, an operating while visibly impaired, 06, attempted larceny from a motor vehicle, 06, resist and obstruct, operating while intoxicated, 07, assault and battery, 21 larceny, 200 to 1,000, 21 larceny, 200 to 1,000, 21 larceny less than 200, 22 malicious destruction of personal property, 200 to 1,000, attempted B&E with intent, 21 larceny, 200 to 1,000, 22 UDAA, 22 possession of a weapon in the jail, 24 driving the license suspended, 24 trespass, 24 driving the license suspended, operating an unregistered vehicle, 25 driving the license suspended, 25 larceny less than 200. In 10, there's larceny less than 20,000. In 2000, driving while license suspended, 02 MIP of alcohol, 02 MIP of alcohol, 02 obstruct police, 05 larceny less than 200, 05 possession of marijuana, 07 interfering with electronic communications, 08 retail fraud second, 14 a jostling, 11 a larceny less than 200, 99 a retail fraud third, and another MIP in 2000. By my count, that's 15 prior theft-related crimes. The record of appearance or flight to avoid prosecution. I don't have her record of appearance here in front of me, but I do know that at the time that this she was arraigned out of the 54A district court, there was a fail to appear there. History of substance abuse or addiction, as Ms. Carey pointed out, she has no convictions for that. I'm not sure if the operating while intoxicated, if those were alcohol or drug related, but the court has nothing in front of it. We do have Ms. Vento representing that she had a meth issue and she had last used just before going to jail. Mental condition, character and reputation for dangerousness. I don't have anything directly on point, but I will note that there is at least an assault and battery and domestic in the defendant's past. Seriousness of the offense. This is a 1-year misdemeanor. She's currently sitting a sentence for a larceny case. Probability of conviction. I don't know how to answer that anymore, because what used to seem like a good probability, I've learned that juries see things differently. So I'll take that for what it's worth. And the likely sentence. I haven't heard all the facts of this case yet, so I'm not going to state anything on that. Employment and financial status and history. I do know that at one point she had been employed, at least it stated she was employed by Bright and Clean, but then the court received communication that that was not the case. So I don't know what that is. Ties to the community. I do know she has substantial ties to this community. She's been here for a very long time. Relationships, I've heard nothing about. No responsible members of the community to step up and vouch for, and on any other facts such as non-appearance and dangerousness to the community. The court agrees that there are some times when people should be released to treatment, and there are times when they shouldn't be released to treatment. Ms. Carey brings up the fact that one does not have to be in jail to go to treatment. And I'm left with somebody who is now been in jail for over a month, indicates their last use was before they went to jail. There's concerns about how they're going to behave when they get out and the tools, but yet has done very limited programming in our jail. And our jail has, for our area and our type of jail, has extensive programming to help people. The court is going to deny the request for release to treatment. I just don't believe it's appropriate at this time. I don't believe that sufficient basis has been laid to show that there is a need for treatment at this time. Turning then to the other requests that bond be reduced. Bond is currently set at a $10,000 cash surety bond with a no contact order and the standard conditions. That was based almost entirely upon the fact that this is repetitive behavior. As I said before, she has 15 prior larceny related charges. She was sitting on a sentence. I realize that $10,000 might be high for Ms. Hall. I do find that she is a threat to the community. And I believe I gave her 60 days for stealing pop cans, if that tells anybody anything as to what a potential likely sentence could be based on her history. But I'm also aware that, pretrial is not to be served as a punishment. But I also have the obligation to keep the community safe. I will reduce bond to a $5,000 cash surety with the same conditions. Anything else, counsel?
No, thank you. No, thank you.
Court next calls the people of the state of Michigan versus Elizabeth Jean Vedler. This is case number 254253 FD. Counsel, I know that the docket says we're here for a preliminary examination, bond motion. Obviously, we're not going to have the prelim today. It was carried over because we ran out of time yesterday. This will be reset for Monday the 20th, the prelim. We'll still have, I'm sorry?
Just so the court knows, we were gonna ask for an adjournment yesterday that we still did not have the labs.
Okay.
The blood draw.
I believe that would be appropriate. My client would consent as well. Yeah.
All right. Ms. Carey, how much time do you think you need?
Wish I could answer that. We checked on it, but I would ask for at least 2 weeks.
Just so the court is aware, Your Honor, I am out the 16th through the 22nd, and then I have a trial at the tail end of the month as well.
Is that a circuit trial?
Circuit trial is 28th, 29th, and 30th. Yes, Your Honor. That's the one with Ryan Mead. I'm recalling those dates correct. I can double check.
That is correct.
Okay.
28.
So do we want to go to November 4th then, to be safe?
Defense would be fine with that.
That's fine.
All right. We will reset this for November 4th. Is that a day I have available?
We do have a prelims at that day with Judge Ransom, a continuation of the Connor and Allen prelim. That might take quite a bit.
That's our normal pretrial prelim day, so
Yeah, it's in the afternoon at 1:30. We could do the morning.
all right, so we will set this for November 4th in the AM due to an anticipated long prelim in the afternoon. We'll do prelims in the morning that day, and we'll just treat PCCs as a paper date. Mr. Hartel, there's a bond request as well.
Yes, Your Honor. Now, the people kindly informed me previously that they would waive notice on that. What my client is requesting is obviously she's been released, so we're grateful about that. She currently, if I recall correctly, is on daily alcohol testing, random drug testing. We asked the court to amend it to pure randoms on both. She's between jobs at the moment. It's not that she's not hoping to find employment, but at the moment, she doesn't have much for fun. She's leaning kind of heavily on family to assist her with that. I do believe the benefits as far as over alleviating any concerns for public safety can still be overcome with those random testings. I would ask the court to consider that. Thank you.
Ms. Carey.
Thank you. We have somebody who is charged with her drunk driving. The first thing, second was just this year. And she was convicted on March 6th of 2025. It was like the second one. And now here we are again. So we're going to ask that the court continue daily testing. I think that is appropriate. I can't give you what her VAC was because there was a blood draw, and we are waiting those results as discussed earlier, and she refused the PBT, so we have no indication. But she was on US 131 driving, although when she was found, she was pulled over, but dangerous behavior and for continued daily testing. And I appreciate the cost factor, but the public safety factor, I think, is higher. Thank you.
Ms. Carey, I have in my notes that a PBT was administered at the jail at a 0.162.
Okay, I did
Okay.
not know that.
And that looks like that came out of the probable cause affidavit, so, all right. Any rebuttal, Mr. Hartel?
No, Your Honor, I'll just ask the court to still factor in what I said previously.
Thank you. Well, while I appreciate the cost to the daily testing, and trust me, I've had conversations with parties, community corrections and others trying to find a way to reduce that cost, because I do realize that $300 a month to be on daily testing is expensive. But the fact remains, Ms. Vedler, you're charged with operating while intoxicated as a third. You were 0.162, and you had just been convicted earlier of another drunk driving. Daily testing, other than locking you up, is the only way I can keep the community safe. So I'm going to deny the bond request.
Your Honor, my client has asked me to inquire, and I apologize for not allocating it a second ago, if we could, the daily testing could be enough just with the alcohol to remove the drug testing, because if I recall correctly, the allegations are for drunk driving and not for drug driving. I realize the court sometimes has concerns about people substituting one offense for another, but I don't believe there was any allegations of any substances beyond the allegations of alcohol. That would still save her a little bit of money so that she wouldn't have to ask for rides and assistance getting to the courthouse to do that. Plus the tests themselves obviously cost money.
Ms. Carey.
I don't see any, honestly, I don't see any drug history, so I will leave that to the court.
Again, Mr. Hartel, I understand that argument, and while there might not be any type of allegations that the court finds more and more when I review the drunk driving assessments, the substance use assessments, it amazes me the people that continue to use at least marijuana while on bond for a drunk driving offense. I go back and look and find that the court did not order that no drug provision. So again, the only way I can make sure that the public is safe is to make sure she's not using any substances. So I'm going to deny that request as well.
Thank you.
Anything else for the record?
Not today, no. Stay on. We're on November 4th.